This just in, the LA County DA Nathan Hockman has asked the court to withdraw the previous district attorney's request to resentence Lyle and Eric Menendez. The brothers have been serving a life sentence without parole for the 1989 fatal shootings of their parents inside their Beverly Hills mansion.
Now, the brothers claim that they were physically and sexually abused by their father, and they've asked for a new trial, clemency, or resentencing. Defense attorney Misty Marris joins us now live to discuss. Misty, this is a bit confusing because the brothers are seeking freedom through different avenues, and while one appears to have been closed off, there is this other avenue, this resentencing hearing that appears to be moving forward.
Yes, Boris, it is confusing because there are several different pathways the Menendez brothers are pursuing. One is what's called a habeas corpus petition based on new evidence that's been discovered after the trial. That is still pending, although the district attorney said he doesn't believe that that holds merit. It will be for a judge to decide. That still exists. Then we have this pathway where the Menendez brothers are seeking resentencing under a California penal code, under the California law. That's what Nathan Hockman was speaking about today. Now, the district attorney's recommendation, there should be no resentencing of the Menendez brothers at this time, but it can go to the sentencing hearing, but the recommendation is vastly different from what prior district attorney Gascon had said. Then you have a third pathway, which is clemency or pardon by the governor. So those competing pathways here. Right now, this presser was focused on the resentencing, although I must say, I watched a press conference, but I feel like I saw a closing argument in court for why the Menendez brothers should not be resentenced.
Well, talk a little bit more about that, because I think, if anything, the case of these brothers has been so impacted over the years by political considerations and just how you have district attorneys thinking about how hard or soft they need to be on crime at any given moment as they consider the circumstances of these two.
Yes, so the prior district attorney, Gascon, had made a recommendation that resentencing was appropriate. That's the motion that's on the books with the court right now. So what we saw was Hockman, who had said he wants to do a complete and full investigation and look into everything, back into the records, before making his office's recommendation. Well, he said you have to withdraw that prior motion made by Gascon's office and take a look at our submission, Judge, because the judge will ultimately decide. As opposed to a 3-page statement of facts that Gascon had, we have 60 pages. Think about the difference between the arguments that are going to be set forth before the court when you have that dichotomy of what the district attorney intends to present. So ultimately, while it will be up to a judge, certainly here, Hockman has set forth a more thorough analysis of the why the district attorney's recommendation is what it is.
Does it seem most likely, Misty, that this is going to wind up being determined by California's Governor Gavin Newsom and whether he decides to grant clemency?
So that is another factor, because it's a totally separate process that doesn't involve the district attorney. The governor goes to the parole board, and the parole board makes a determination about whether or not someone should be eligible. They list out all of the factors, they do this analysis, and the governor takes it into consideration. But something I found very, very interesting in this press conference is that Hockman, when laying out his position on this, and the office's position, went back and used a prior decision made by Gavin Newsom in the Sirhan, that's the person who assassinated Robert F. Kennedy, where the parole board actually said he should be eligible, and Governor Newsom said, no, he should not. And Hockman actually mirrored that framework that Gavin Newsom had set up when making that decision, and did his analysis based on that. So I think, Boris, there is some acknowledgement by Hockman that he knows this other path exists, and he's actually kind of setting forth the arguments that would be against that. However, Gavin Newsom can act independently as the governor in conjunction with the parole board. So it certainly is another path.
Really a fascinating legal study for a case that is so divisive and so controversial. Misty Marris, thank you so much for breaking that down for us.
Thank you.